Hello and good morning, everybody. How are you? I hope you're all well. Thank you very much for joining today. So we've got a brief webinar to do. As I said in our little lead up to this, there's a couple of subjects I wanted to cover. One of them is a recent case study looking at Section 21 and the implications of your gas safety certificates. There's a brief market roundup as well. And there's a couple of very interesting little pictures that I wanted to show you that I found on some agent websites around the world, which you might find a little bit interesting. It's something more light-hearted at the end of our webinar today. So I hope you're all well. I hope everybody's continues to stay safe and your families are the same. So let's crack on. And this is the August instalment of your James Anderson webinar. So I'll share my screen with you as always. So firstly, thank you to everybody who has been in touch with me over the recent months. And yeah, I hope that I've been of some assistance and help to you all. What I wanted to do really was say thank you to Basil, who again suggested a bit of case law. I know that you like that, Basil, so I hope today this appeals to you as it does to everybody else on the webinar. Right, here we go. So I guess really you all know already about your gas safety certificates. So just a quick reminder for you. I know this is sort of day one of landlord and agent school, but just to remind you, the actual obtaining of a gas safety certificate is very easy. I think you'll all agree. All you need to do is have a gas safe engineer attend the property and carry out the inspection and provide you with a certificate. Pretty easy, right? Then following that, you need to renew your gas safety certificate every 12 months. You need to provide those certificates to your tenants within 28 days of the inspection and prior to occupation if it's a new tenancy. If you don't do that, of course, there are implications for the landlord if you fail to stick to the legislation and the regulations. Like I said, pretty common knowledge. We've discussed this before in our webinars, so I hope it's not news to you. So it was actually the provision of gas safety certificates that reared its head and became a sort of keen point in a case a few years ago. Now, there have probably been several cases involving gas certificates and possession cases, although this one was a fairly simple one and highlights the aspects of this case and the problems with it. So the case was Caridian Property Limited versus Monty Schultz. And this was from 2018. And really what happened as an outcome of this case, where the landlord failed to supply a gas safety certificate, it was deemed that the landlord's failure to serve the gas safety certificate would nullify all future possession claims under the Section 21 of the Housing Act 1998 and was a legislative breach that could not be fixed. So that sounds a bit tough. Look, I'm not arguing with the fact that gas safety is really, really important, and I can't imagine anyone would, because it is. It's really important. It's health and safety. It potentially could be a tenant's life at risk here, so no one's going to argue with that, really. However, it does seem very detrimental to a landlord and a tenancy if that is the case. So if you haven't served your gas safety certificate properly, are you then caught in a position where there's no end in sight and a landlord's bound by a tenancy they can't get out of? You know, that's fairly restrictive and rather shackling, I would say. You know, and let's face it, it might not actually be the current landlord's fault. An example of this is where a landlord might have bought a property with a tenant in situ and they happily took on that tenant as part of the purchase. What if that previous owner hadn't fulfilled their obligations and done this properly? Or what if the onus was on the agent and they hadn't fulfilled their obligations? So you can see that it's quite a harsh and tough measure in terms of the outcome of this case. You know, and it's commonplace that landlords and agents provide tenants with documentation very shortly after the tenancy starts in a tenancy pack, with EPCs, with gas certificates, and all the necessary documentation. So it's a bit tough, this really, and I hope you agree. So this sort of came into play again with another case that actually came through the Court of Appeal ultimately earlier this year, but it actually started some time ago. Now, the case of Trecarrell House Limited versus Rounsfield is what we're going to look at. Now, just to give you a bit of an understanding of what took place in the lead up to these cases, let me just give you a bit of insight. In February 2017, Miss Rounsfield became the assured short-hold tenant of a flat owned by Trecarrell House Limited, and they were the landlord. So the landlord didn't provide a gas safety certificate before occupation, but there was one provided in November 2017, and the date on that certificate was January of that year, 2017. Then in May the following year, the landlord served notice, Section 21 under the Housing Act 1988, and issued possession proceedings. They wanted the property back for whatever reason. Now, the tenant defended the claim on the basis that there was no gas safety certificate provided to her, and therefore the landlord wasn't entitled to serve notice under Section 21. And the Deputy District Judge dismissed the landlord's defence and granted, sorry, I beg your pardon, the landlord dismissed the tenant's defence and actually granted the possession order to the landlord. So the landlord was just about to get his property back. Now, there was a little spanner in the works because the tenant was allowed to appeal, okay? And as a result of that, the circuit judge held that actually a failure to provide a gas safety certificate before the tenancy commenced was not capable of being remedied, and granted the tenant's appeal against the possession order. So this poor landlord thought that, great, I've got my property back. Then through Court of Appeal, all of a sudden that was reversed, and the tenant defended the claim, and Truro County Court denied the landlord the right to serve the Section 21. So, of course, this landlord now has Miss Patricia Rounsfield in his property, and he can't get her out. Really difficult situation to be in for the landlord. And as we saw in the previous slide, does that mean you're then bound? What can you do? So what actually happened was that the Court of Appeal granted the landlord a chance to appeal against this ruling. So it's swinging back and forth between landlord and tenant here, isn't it? And so the landlord did appeal. And the tenant actually served a new factual point known as a respondent's notice, saying that actually there was a further gas certificate carried out in 2018 in February, and that hadn't been provided to her either. So the tenant did have a point here, let's face it. So let's have a little look at what happened. So eventually, in February 2020, the landlord's case was heard by the Court of Appeal. So this started back in 2018 when the landlord first tried to serve notice. So, you know, we're getting on to 2 years down the line here, which you'll probably agree is a long time to be waiting to get your tenant out. So the case was heard in February this year, and only recently, on June the 18th this year, there was a judgment handed down from the Court of Appeal, and this is what the judge said. Although the point is not straightforward, I am not therefore persuaded that for the purposes of Section 21A, the obligation to provide the gas safety record to a new tenant prior to the tenant taking up occupation cannot be complied with by late delivery of the gas safety record. Late delivery of the document does provide the tenant with the information he needs. As a matter of construction, I therefore prefer the view that as a result of Regulation 2.2, the time where the landlord is in breach of paragraph 6b ends for the purposes of section 21A once the gas safety record is provided. Now, obviously, on first glance, that is a little bit wordy, and yes, I had to read that a couple of times myself. So let's simplify this. What does it actually mean to you and me? So what it means is that a section 21 can be served as long as the gas safety certificate is provided before the service of the section 21, that there is a valid certificate in force at the point of occupation, and that subsequent certificates are carried out and provided to the tenant. So what it is saying here is that it is possible to correct the initial wrongdoing or error by the landlord, rather than saying, well, tough, that's it, you know, case closed, sorry landlord, your tenant's in there as long as they want to be, because obviously that is totally unacceptable. But this sounds much more positive. So I think you'll agree there in terms of, you know, yes, it's not great that a tenant isn't provided this information, but as long as you have the gas safety certificate, there is some movement and leniency here, okay? So really, to sort of summarize what has happened here, the landlord did carry out the inspections, which is the important bit here, okay? And it was the actual provision of the certificate that was the problem. So what happens then if there wasn't a gas safety certificate actually carried out in the first place? Because what we're saying is here there was one, but it just wasn't given to the tenant. So if there is no gas certificate at all, what does that mean? Well, what it means, unfortunately, as you've probably already guessed, the section 21 would have been completely invalid. The lack of a gas certificate in itself is pretty serious. So yeah, no certificate, invalid section 21, and you won't be able to serve notice effectively on your tenant, okay? The Court of Appeal did back this up, and this is what they said. It is not held that a landlord that did not have a gas safety certificate before the tenant moved in is permitted to fix that breach by obtaining a gas safety certificate later. So the golden rule here is have your gas safety certificate in place and sorted before your tenant moves in. Again, in this situation, a daft mistake by the landlord led to pretty much 2 years of trying to get possession of the property, which is a long, long time. I'm sure you'll agree. So yeah, it's an important point that we really need to take note of. So if I could give you some advice then, it would be this, and it's very simple. Keep your records. You've heard me say this a number of times, and it is really important. So there's a few steps here that you can do so that you can serve a section 21 effectively, and get your property back when you need it. So first thing, like we said, get your gas safety certificate in the first place. That's pretty easy, and provide it to your tenant at the start of the tenancy. Note what that expiry date is. Put a note in your diary, put it in your email calendar or somewhere where that is going to remind you. And then just renew the gas safety in good time, probably around month 11 out of those 12 months. Get it booked in and get your engineer round maybe a week or two before it expires. Provide that new certificate to your tenant, of course. And number 6, keep a comprehensive audit trail. You know, really 2 years is really the minimum requirement. Any email, any phone call you've had, receipts and documents relating to your gas safety certificate, keep them all in a file. It's a bit like insurance, guys. You know, your car insurance, your house insurance, hopefully you never ever need to use it. But when the chips are down and something does go awry, then you've got that there and it's there to protect you. So protect yourselves and keep these records. So I'm guessing that that's pretty easy for everybody, right? We saw there that our landlord, Trey Carroll House, made an error in their administration, but they are able to fix it. Key point being the gas certificate was available and valid at the start of the tenancy. If you don't have that, then really you're going to find yourself in some hot water. Okay, so moving on to our next section. Like I said, I just wanted to show you a brief look at what has been happening in the lettings market recently. Obviously, everybody's keen to see what's going on since we broke out of lockdown. And do you know what? July was a very, very busy month. Let's face it. There was a really high number of deals agreed, and there were high stock levels. Now, what we're going to look at here is a London-wide view of the lettings market. And as you probably know, July and August are really traditionally the busiest months of the year for lettings. So yeah, it's really looking fairly positive. However, look, let's not beat about the bush. Activity is still behind where it was this time last year. The market is improving, and that's a lovely thing to see, and we're all quite excited about that. But actually, the new lets in July, in comparison to that time of July last year, is roughly 30% down. So there are improvements, but we're not really back to where we were this time last year. So what I'm going to do is just show you a little graph, and you can understand this a bit better. So actually, at the start of August, stock levels were pretty high. Across London as a whole, this was at 42% higher than the same point in 2019. But the reality of this came from a big flurry of activity in June. Now, if you can look at this graph here, on this side, I hope you can see my mouse cursor, but if you look on the right-hand side to June 20 and July 20, the dark columns are new lets agreed, and the light columns are new instructions coming to the market. So, in terms of the actual new instructions coming on, yeah, June was great. Look at that. That was actually up on last year, which is pretty obvious. But then when we get to July, that has dropped off again. And really, June showed a 28% increase in new stock compared to 2019, but July only had 2% more. And that figures, there's all this pent up property, landlords not wanting to put their property on the market during lockdown, which is pretty obvious. And here it is. There's a massive influx of stock in June. Now, what this means, obviously, higher levels of available stock will always put a downward push on rents. So tenants have got lots and lots of choice, and therefore they are more likely to negotiate on asking rents. Okay. We can look at some of the rents, but really comparing rents achieved in June and July this year with the same period in 2019 shows an annual fall. So why don't we have a little look at the rent side of things? So this is June and July, and this is London-wide, remember. Obviously, there are little fluctuations, and obviously some areas have their own property bubble, should we say. And certainly I would say the areas that we work in, Putney and the surrounds, Mortlake, Barnes, East Sheen, I would say that we're probably more prime fringe area on this graph, which is the third one across from the left, rather than prime London or central London, of course. Now, achieved rents, like we said, are actually 8.4% lower than June July last year. So that's quite a significant change. And that's the overall across London, which is the far right-hand column here. So you can see just over here, 8.4% London as a whole. So rents are decreasing somewhat compared to last year. In July 2020, overall, tenants secured an average discount of 8.2% off the initial asking rent, which is fairly high, I would say, especially when you look at this figure at the same point last year. In July 2019, this figure was 3.9%. So it's pretty much doubled in that time. Now, in terms of our area, like I said, we'll look at the fringe London market. That is roughly 6.4%. So not quite as heavy as if we were in central London, but still, you know, a fairly significant negotiation pattern going on through July this year. Now, there's a number of reasons for this, not only all the health and safety aspects that we're having to deal with at the moment, but also do be aware that, you know, things like corporate relocations into London are quite low this year for obvious reasons. Again, students, foreign students coming into London to study, they are very low this year as well. So all of these things contribute. And also, don't forget, the general lack of jobs that are available at the moment prevents people coming to London to take up new jobs, whether that is domestic or whether they're coming from overseas. There is that element as well that we need to be aware of that will always affect these figures. And they're just a few factors, you know, that affect what's happening in the lettings market at the moment. But like we said, where the stock is high, tenants will want to negotiate. And of course, you know, you've just got to be realistic with your expectations on what you might achieve for rent this time round if your property is on the market. Because, you know, if we don't set that expectation at the correct level, that might mean that you end up with an empty property, and then therefore you've got a longer void period, which isn't a good situation for any landlord. I'm sure you will agree. Having said that, there was a lovely deal that I saw come through this morning from our team in Sheen, and they've agreed a property, and actually they've gone over and above the rental figure that was achieved on the previous tenancy. So that's really good news. You know, hats off to the team in Sheen, and I know that that landlord is really, really pleased with that result. So there's some positivity there, and I hope that that continues through September and into October, because, you know, there is a market there. You know, admittedly, we might not always get the same rental figure that we got previously, but do you know what? My team will try their absolute best to do that or improve on that for you, okay? So I hope that gives you a little snapshot of the market, where we are at the moment. I'll be interested to see what the results are from August, of course, but this is a London-wide view, like I said. Unfortunately, I don't have a sort of SW13, 14, 15 and surrounding areas analysis available, but this gives you a good picture of what's going on, okay? So we seem to have whizzed through that, actually. So, you know, I hope that you've been able to take all of that in. If you've got any questions, obviously I'll show you at the end where you can get hold of me, and we can discuss things further if you wish. Now, for the final section of today, I just wanted to show you something completely different. I know usually it's sort of legislation and doing the right thing as a landlord, as an agent and stuff like that, but I just wanted to lighten it up a bit for you, because it's a wonderful, wonderful world that we live in. And in our day-to-day as property agents, you come across things that make you smile, sometimes want to make you cry. I'm not going to deny that. And some things that just you have no answers for at all. And so that sort of brings us to you wouldn't believe it section of the webinar. People's homes, you know, are always different when you go in, and they're always quite interesting. There are homes that are immaculately presented, and you know, even just walking through there, gosh, I don't want to touch anything because they're so beautiful, and they're like show homes. And of course, then you get some homes that are rather tired and need a little bit of work, but everybody's different. Everybody has their own tastes, and what suits someone may not suit another. You know, different strokes for different folks, shall we say. Now, what I wanted to show you was just a slightly amusing insight into agent photos, because when you see properties online, I hope that they are the best version of that property that you can show. You know, that's your first foot forward in your advert to the world to try and sell or let that property. So it does baffle me sometimes when we see photos that leave you asking the question, why, how, and or what is that? And I hope here are 3 examples of that. So here's your first one. Now that's quite a busy little bathroom, isn't it? I mean, I don't know what the plan or the thought was behind this. 2 toilets, a bidet, a sink low down and a sink high up. You know, it beggars belief, really. But I do wonder, what if it's a family home and they're always fighting for the bathroom in the morning, but the house is too small to create another bathroom or an extra cloakroom, so why not just chuck another toilet and sink in there, and then that solves the argument, doesn't it? Or does it? I'm not so sure. So yeah, there you go. That's our first one, which is you know, quite tame, shall we say. Now, those of you that can appreciate art might enjoy this next photo. Again, it's a bit of a baffler, but check this one out. Wow. Now, I know that the first thing that jumps out is the Candy Floss Pink Suite, which in itself is pretty special, but it's the artwork, isn't it, on the floor there. Now, I'm going to hazard a guess. Is that a mermaid? Maybe answers on a postcard, if you like. But yeah, if it is a mermaid, to be honest, I can't vouch for that. I've never seen a mermaid. That might be what they look like. But if you can find anyone that has seen a mermaid and can vouch for that, then please put them in touch. But yeah, other than issues of anatomy, perhaps, and an ice cream, maybe, yeah, I think someone's done pretty well here. So yeah, well done there, guys. Now, I'm just going to show you one more. And this one actually is remarkable, absolutely remarkable. And I think it's somewhere between remarkable and maybe a little bit disturbing. So brace yourselves for this one. Yeah, I don't think there's much else I can add. Oh my goodness me. What on earth were they thinking? I mean, clearly the person who's actually designed it and created it has definitely got some serious talent. That takes some work, doesn't it? I think we'll all agree. But if I turned up at a property and I saw that, I think I would probably walk the other way. And you know what? If I was busting for the loo, I reckon I could hold on for a few more minutes till I got back to the office, you know, before making use of that particular toilet. So yeah, wonderful piece of porcelain, I guess, but oh my goodness, what was going through your head when you put that toilet in? Anyway, it'll be a lucky tenant that gets to move into that property, won't it? So on that bombshell, we will finish the webinar. I almost feel like saying, if you've been affected by the photos you've seen today, you can talk to us. But yeah, let's talk. If you've got any questions, you know, in all seriousness, then please do get in touch, whether that is your section 21, whether it's gas certificates, or any question you might have for myself or the team. We're here to help. So yeah, I hope that has been an interesting insight into lettings today. And again, in September, towards the end of September, I hope to bring you another webinar that we can all share together. And yeah, some more news. Let's see what the market's doing perhaps, and if there's anything significant going on, which I think there will be, because already there's news about Section 21 extensions of you know, the non-eviction until 20th September, and it's looking like that the notice period for Section 21 is going to be extended from 3 months to 6 months. So I think we're going to have a fair bit to talk about in our next webinar. In the meantime, please you know, look after yourselves, be kind to each other, and I hope to see you very soon. Thank you very much, everybody. Bye.